Good morning, students. This lesson is of Class 8 for the subject of History and Civics, Chapter 13, the Judiciary, which we will continue from page number 148 of your textbook titled Past and Present 8 and is being submitted to you on 30th November 2020. This voice is of Millie Bhatnagar. Students, in the previous lecture, we had studied about the judicial system in India. We know now that India has a single integrated judicial system with the Supreme Court at its apex. It has varied powers and functions. In this part, we will study about the High Court, Subordinate Codes, and Lok Adalats. The Constitution of India provides for a High Court for each state. Parliament may, however, establish a common High Court for two or more states. This depends on the area and the population to which a High Court has to serve and the amount of work it has to handle. For example, the High Court of Chandigarh is shared by Punjab, Haryana, and the Union Territory of Chandigarh. Students, this is the High Court of Chandigarh. Composition. Each High Court consists of a Chief Justice and such other judges as the President of India may appoint from time to time. The Chief Justice of a High Court is appointed by the President of India in consultation with the Chief Justice of the Supreme Court and the Governor of the concerned state. Other judges of a High Court are appointed by the President. In this case, the President shall consult the Chief Justice of India, the Governor of the state, and the Chief Justice of the High Court in matters of appointment of a judge to the High Court. Eligibility. According to the Constitution, a person shall be qualified for appointment as a judge of a High Court under the following conditions. Number 1, he or she should be citizen of India, should not be over 62 years of age, has held a judicial office in the territory of India for at least 10 years, or has been an advocate of a high court for at least 10 years. Students, this is the photo of Anna Chandi, who was the first woman judge of a high court in India. This is the list of high courts in India. You can look here for the year of establishment and the area which the various high courts cover under their territorial jurisdiction. Powers. High courts have original jurisdiction, that is, the power to hear and decide cases at the first instance. Along with the Supreme Court, it enjoys original jurisdiction for the enforcement of the fundamental rights guaranteed by the Constitution. The High Court also has original jurisdiction in cases such as election petitions challenging the election of the members of Parliament or a member of the State Legislative Assembly or other local bodies. The High Court also has appellate jurisdiction, that is, power to accept appeals against the decisions of district courts in civil as well as criminal matters. The High Court is also a court of record like the Supreme Court. Its judgments and orders are preserved as a record to be referred by its courts in future cases. Writs. A writ is a form of written command in the name of a court to act in a particular way. It is issued by the Supreme Court and the High Court to make the right to constitutional remedies available to every citizen. There are 5 types of writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto. We will study about them in detail in class 9th. Let us take a short break, and you may kindly pause your recording for 3 to 4 minutes and write the answers for the following questions in your notebook after listening carefully to them. Question number 1. Who appoints the Chief Justice of a High Court? Question number 2. For how many years should a person be an advocate of High Court to qualify as a judge? Question number 3. What is the meaning of appellate jurisdiction of the High Court. Question number 4. What are writs? Let us discuss the answers now. Answer number 1. The Chief Justice of a High Court is appointed by the President of India in consultation with the Chief Justice of the Supreme Court and the Governor of the concerned state. Answer number 2. 10 years. Answer number 3. It has the power to accept appeals against the decisions of district courts in civil as well as criminal matters. Answer number 4. A writ is a form of a written command in the name of a court to act in a particular way. Let us resume our lecture now. Students, this is an image of the District Court of Chandigarh. Do you know that the District Court is a part of the Subordinate Codes? Let us study about the Subordinate Codes. Subordinate codes are the codes which function at the district level and below. The organization and structure of the subordinate codes are generally uniform throughout the country. We know that for administrative convenience, each state has a number of districts. These districts have two types of codes: civil code and criminal codes. The Court of District Judge is the highest civil court in a district. Under the Court of District Judge are the courts of sub-judge, additional sub-judge, and the municipal courts. The courts of district and sessions judge and additional and assistant judges and the courts of first-class magistrates come under the criminal courts. Many disputes arise from the non-payment of land revenue. These are settled by the revenue courts. As you can see from the picture, this is a Nyay Panchayat in progress. So let us study about Nyay Panchayats. In the rural areas, there are Nyay Panchayats for trying petty civil and criminal cases. It can impose fine but cannot imprison anyone. This is the picture of National Lok Adalat in working. Let us study about the Lok Adalats. In a vast country with a large population, there are hundreds of cases coming up before the courts every day. The legal process has become lengthy and expensive. For providing speedy and economical justice to the poor people, Lok Adalats have been introduced. They are presided over by retired judges. The legal procedures are also simplified, and the disputed parties can argue their cases directly without advocates. The first Lok Adalat was held in Delhi on October 6, 1985, in which 150 cases of payment of compensation to the relatives of accident victims were solved. In the end, we will study about the legal aid scheme, which makes available free legal services to some groups of people, those belonging to the scheduled caste and scheduled tribes, women and children, mentally ill and physically challenged, those who cannot pay for legal services. Students, please read the chapter again and complete the following home assignment. Quick quiz, page number 149. Fill in the blanks, number 5 and 6. Tick the correct answers, 4 and 5. Answer in 1 or 2 sentences, 4, 5, 6, 7 and 8. Answer these questions 4 ABC, 5 ABC and 6 ABC. With this, we come to an end of this interactive session. Thank you.